Well, welcome to this session on 3 Supreme Court cases this term that deal with religious liberty. I'm James Phillips, and I'm with the Wheatley Institute here at BYU, and I'll be moderating the session. I will keep the introductions very brief. You can look up all the rest of the information on our distinguished panelists online. So we're going to first hear from Michael Helfand, who is a law professor at Pepperdine University and a visiting law professor at Yale University. He's going to speak to us about the Mahmoud versus Taylor case. Then we will hear from Nicole Garnett. She is a law professor at the University of Notre Dame, and she's going to speak to us about the St. Isidore versus Drummond case. And then we will hear from Shawn Gunnarson. He is a shareholder with Kirton, McConkie, and he will speak to us about the Catholic Charities Bureau case. And with that, I'll turn it over to Michael.
Okay. Good morning. Let's just start like this. How many people here are lawyers? Okay, we had like a little bet going, and I lost by a lot. Like it wasn't even close. Okay, good. I'm going to start us off with Mahmoud v. Taylor. In many ways, maybe one of the highest profile, maybe the highest profile of the religious liberty cases currently before the Supreme Court. The case is currently pending, and the facts of the case go somewhat like this. The Montgomery County Public Schools in 2022 adopted a new curriculum, a curriculum for its English language arts. And as part of that new curriculum, they introduced a variety of LGBTQ inclusive storybooks. Some of the names are Prince and Knight, Intersection Allies, Born Ready. And the goal of this new curriculum was kind of multifaceted. It was for inclusion, it was to support literacy and social emotional learning, it was to prevent bullying, reduce stigma of the LGBTQ community. Initially, the Montgomery County Public Schools, let's call them Montgomery County from here on out, had an opt-out. And here's how this worked. The way the opt-out was supposed to work was parents would be informed that their children, in this case, this curriculum impacted kids in classes from pre-K through 5th grade. And the way the opt-out was supposed to work, parents would be informed in advance that the LGBTQ inclusive books would be read in a particular classroom. Religious parents, all parents, but the issue is for religious parents, would be given the opportunity to opt out of the storybook reading hour if they had some sort of religious objection, if they felt that the storybooks were not in line with their religious commitments. However, after some consideration, Montgomery County decided to get rid of the opt-outs and tell parents that they would not be informed in advance that the stories were going to be read, and in addition, that their children would be required to stay in class and participate in the reading hour. As a result, a variety of parents, group of parents, Muslims, Catholics, Orthodox Jews, filed suit. They filed suit not to change the curriculum itself, but to say that they were constitutionally entitled to an opt-out. Some of the interesting facts kind of on the heels of the rollout of this curriculum and the rescinding of the opt-outs were meetings later that spring and summer where parents met with the school board, and there are allegations, maybe even evidence in the record, that some members of the school board used a variety of language that might indicate some sort of what we might call animus towards religion or religious objections, describing them as affiliated with hate and related to white supremacy. And that was part of the reason why the Montgomery County School Board decided to prohibit or continue to withhold these opt-outs. Now, my goal right now is to tell you a little bit about 2 ways in which this case might be decided. You know, there's a very, very broad way in which this case might be decided, and there's a narrow way in which this case might be decided. I think conventional wisdom, and conventional wisdom is often wrong. Conventional wisdom is that the Supreme Court will find in favor of the plaintiffs in this case, will find in favor of the religious families seeking a constitutional opt-out. Again, not wanting to change the curriculum itself, but a constitutional right to be informed that these books are going to be read and to have the opportunity to pull their kids out, have them in some other classroom while the books are read, if they have some sort of religious objection to the content of the books. So I want to walk you through the 2, the narrow version and the broad version, and tell you about the different implications of the 2. And with that, I'll sit down and you can listen to the far more accomplished members of this panel. Okay, good. So let's start with the narrow version. Here's how the narrow version of this case goes. You know, one way to look at this case is like your typical religious discrimination case. And here's what I mean by that. You know, the general rule, since like 80% of you are lawyers, the general rule when it comes to the First Amendment is that rules, regulations, statutes, the way they work is they have to be neutral and they have to be generally applicable in order to satisfy First Amendment scrutiny. What I mean by that is neutral, they can't target, discriminate against religion intentionally, and they have to be generally applicable. They have to apply across the board. And if you just take that basic framework, there are good reasons to find in favor of the parents in this case. Let's take neutrality. I mentioned to you that there were some comments made by some of the members of the school board saying things like, oh, your religious objections in these circumstances, they're so hateful. This is like white supremacy. This kind of language the Supreme Court has found before is evidence of animus, meaning when government officials use that kind of language to describe a religious objection to a particular government regulation, the Supreme Court, in a case Masterpiece Cake Shop, said that can often be enough evidence for the court to say, you're discriminating against religion, that's animus against religion, and as a result, your rule, given kind of your rationale for it, is discriminatory and prohibited by the First Amendment. Or take kind of the second part of it. The second part of it is generally applicable, applied across the board. You know, one of the interesting features of Montgomery County Public Schools' decisions when and where to provide opt-outs is, yes, in these circumstances, they didn't say to the religious parents, you know, we recognize that you have religious objections to the content of this curriculum, and we're going to give you an opt-out. They said, no, we're not going to do that in this case. But in other cases, they actually had provide opt-outs. In some of the health education, Montgomery County says, you know, some of this might be religiously problematic for some of you. You can get an opt-out from those circumstances. Parents can say, my children are not going to come to that particular lesson. And when you start seeing how sometimes there are opt-outs and sometimes there aren't opt-outs, one gets the sense that, oh, wait, this law isn't generally applicable. It doesn't apply across the board. And in some circumstances, the Supreme Court has said, when you have rules that look more Swiss cheese-like and not quite across-the-board rules, that can also mean that the First Amendment applies and the law is unconstitutional. Now, why do I call this the narrow version? If you're probably puzzling about this and you're thinking, oh, what might the Montgomery County School Board do in response to a ruling for the Supreme Court, or maybe not even Montgomery County, other school boards? Note that if the Supreme Court adopts the narrow version of this case, you know, you could avoid the constitutional problems by, I don't know, not saying things that associate religion with white supremacy, which might not be the hardest thing to do. Oh well. Or what you could do is you could have across-the-board rules. You could say no opt-outs for anybody. Note, if you say the right things and do some of the right things, you could still say to parents, oh, you don't get a religious opt-out from a curriculum that is problematic for your faith commitment. So it's narrow in that it wouldn't have widespread implications for other school boards adopting similar kinds of policies. School boards could navigate these constitutional requirements and still have a curriculum, maybe even for kids as young as in pre-K, that had LGBTQ inclusive themes, and religious parents would not necessarily be entitled to a constitutional opt-out. Okay, so that's the narrow version of the case. Let's go to the broad version of the case. Because I like asking people to raise hands, largely to make sure you're still awake. How many people here have heard of the case Wisconsin v. Yoder? Holy cow. That's a lot of people. Okay, good. This is the most intelligent audience in the history of mankind. Okay, good. Okay, good. Okay, so great. So Wisconsin v. Yoder, as all of you know, that's wild. Wisconsin v. Yoder, case from 1972. This is what the broad version of the argument looks like. So in 1972, the Supreme Court decides this case. You have a couple of Amish families, 3 Amish families, who are take their kids out of school after 8th grade. And Wisconsin says, no, we have a compulsory education law. You have to send your kids to school. And they say, well, we're religiously committed to giving them an alternative kind of education. We're not sending them to public school. We're not complying with your your compulsory education law. And we think we have a constitutional right not to send our kids to school, but to provide them with this alternative form of education. And the Supreme Court finds in favor of these parents in 1972. The Supreme Court says, you guys have a constitutional right to keep, based on the First Amendment, the Free Exercise Clause, to keep your kids out of school and to give them this alternative form of education. Now, nobody knows at this point what Wisconsin v. Yoder stands for. And the challenge is that subsequently, Supreme Court doctrine has shifted in a way that seems in tension with Wisconsin v. Yoder. The Supreme Court has narrowed what the Free Exercise Clause says or means, but at the same time, it's also left this case on the books saying it's still good law. And one of the puzzles that comes up in Mahmoud is, well, what does Wisconsin v. Yoder stand for? And in this decision, the Supreme Court could give a very broad interpretation to what Wisconsin v. Yoder stands for. In Mahmoud, the Supreme Court could say, Wisconsin v. Yoder is good law. Religious parents have a right to control the religious upbringing of their children, and as a result, they're constitutionally entitled to an opt-out. Just like the parents in Wisconsin v. Yoder could pull their kids out of public school and give them an alternative education, similarly, the parents in Mahmoud should have the right to pull their children out of a particular piece of the curriculum, and that could be justified by a broad reading of Wisconsin v. Yoder. Now, in fairness to Montgomery County, they have plenty of counter-arguments as to why this should be different. In their view, there are a lot of different kinds of consideration. Those considerations include tons of families requested opt-outs. This isn't feasible from the perspective of administrability, where the kid's going to be, how's it going to work. This is very different than Wisconsin v. Yoder. We're not, in Yoder, they wanted out of the entire school system. Here, they want in just pieces, and that makes it hard for the school. Even more than that, in Wisconsin v. Yoder, there the Montgomery County says the stakes were different. We were telling the parents, you have to, if you send your kids to school, they're going to be pulled out of a whole religious lifestyle that's going to undermine the Amish community. Here, there's no burden on the families, at least so Montgomery County says. They just have to listen to a school book. Will the court buy these arguments? If you ask me, unlikely. Well, you did ask me, I guess, because I'm here. But unlikely. But those are the distinction the court's being asked to make, and unlikely that the court would buy these sorts of distinctions. What might the court buy when it comes to the broader argument? Why might the court go for the narrow version of the case over the broad version of the case? And one thing that came up at oral argument is the problem of line drawing. One of the problems is if you give religious parents certain kinds of constitutional rights to subvert compulsory education law, what do you do in kind of boundary cases? And here, Justice Kagan raised a very interesting issue related to some litigation ongoing in New York right now. Here's what she asked. She says, this is from oral argument, suppose that parents in a Hasidic, a certain brand of Orthodox Jewish community say, we don't want to teach our children math or English or history because that conflicts with our religious beliefs. Would you say that under Yoder they have a constitutional right to do that? Meaning, how far can religious parents push this right if we go for the broader reading of Yoder? Can they say, well, we don't want to teach our kids anything and we should have the right to do that? And you can see the allure of this kind of boundary question. What do we do on the outer limits of this doctrine? And it's a forceful question. One got the sense that a number of justices were interested to understand how they might draw lines around a robust reading of Yoder. And it wasn't clear that the government gave the strongest answers in response. You know, one of the things that I thought I'd share with you today is I've had the pleasure of filing amicus briefs on behalf of the Orthodox Union in this litigation in New York, and we've actually proposed the following way to police the boundary here. One way you might think about this is, well, in cases like math or history or science, where there's some pushback from certain communities in New York, there the government has a compelling government interest in ensuring the basic education of each and every child. Children have to be economically self-sufficient. They need an education to do that. Children need to be civically engaged. They need an education to do that. The Supreme Court, since Brown v. Board of Education, has emphasized these as compelling government interests. And whatever one might think of the stakes in Mahmoud, there's a good reason to think that whatever the government's interest is, maybe it isn't quite compelling. Now, in New York, I should flag, there's good reason to think those laws are unconstitutional, unrelated to a Yoder doctrine, more because New York seems to pick and choose in strange ways how it applies its compulsory education law, in ways that might not be neutral, might not be generally applicable. But so long as government does apply rules, a compulsory education law, that is neutral, that is generally applicable, and advances a compelling government interest, those sorts of rules would likely withstand constitutional challenge. Instances like Mahmoud, maybe, where the compellingness of the government's interest isn't quite compelling, maybe those are the ones that should lose to a robust reading of Yoder. And maybe if the court finds a way to figure out how to police this boundary and make sure the right cases are challenged and the wrong cases, those are the ones that are upheld, maybe if it can police that boundary successfully, we'll see a broad reading of the decision in Mahmoud. Thank you very much.
Okay, so Michael left out my favorite book from the LGBTQ reading series in Montgomery County. It was the Pride Puppy book for 3-year-olds that the curriculum required. You can see why the parents were upset. One of the things that the children had to do in 3-year-old pre-K is point to the leather. This came up in oral argument in the Pride Puppy book. But that's not what I'm going to talk about. I'm going to talk about a case called, we might call it like, the little kids book, speaking of little kids books, the little engine that could. I'm going to talk about St. Isidore of Sevilla Catholic Virtual School versus Drummond, which we might call the big case that couldn't. It's a long story. It was a deadlock court. Justice Barrett recused. I was involved in this case since its inception. So that was disappointing to me, to say the least, although I don't think we thought we were ever going to get to the Supreme Court. So St. Isidore of Sevilla, which has 2 names, was a consolidated case. It asked the question whether it was unconstitutional for a state, Oklahoma, to prohibit religious charter schools. So who knows what a charter school is while we're in the hand raising? Okay, good. Charter schools are privately operated. They're called public schools, and they operate pursuant to a contract between what's called an authorizer, which in most states is a government agency, but in some states can be a university, even a private university, even a religious university, including in Oklahoma, or a nonprofit in a few states, authorizers. So they enter into a contract with a private organization that runs the school. The goal of charter schools, which have been around since 1991, they are available in 47 states as of last month after North Dakota passed a charter school law. The goal is really to stimulate educational innovation, educational pluralism, and increase educational opportunities by enlisting private actors to create new and innovative schools. Private charter schools, they're regulated differently in different states, which turns out to maybe have some pretty significant constitutional implications. But by and large, they are freed from most of the regulations that govern traditional public schools. And again, they're privately operated, but they are importantly called public schools. So most states with charter school laws prohibit religious organizations from running them. And all states with charter school laws prohibit the charter schools from being religious schools. That is, they require them to be, quote unquote, non-sectarian in their operations. Now, most of you know, because you seem to all be lawyers, that in a series of recent cases, the Supreme Court has articulated a non-discrimination rule that goes something like this. If the state or the government, any government, chooses to enlist private entities, private organizations, in order to promote public goals by giving them public benefits, vouchers, for example, or money to run a soup kitchen, or money to help the foster care system. If the state chooses to do that, it may not exclude religious organizations from participating, nor may it require them to only engage in secular conduct. So these cases, Trinity Lutheran Church, 2017, Espinoza versus Montana, 2019 or 20, and then finally Carson versus Macon in 2020, 2022, Michael? 2022, they basically articulate this non-discrimination law. And in the education context, it goes like this. The state need not subsidize private education, but if it chooses to do so, it may not refuse to subsidize religious education. And Carson is an important case because it says what happened in that case, Maine had a modest voucher plan for kids who lived in rural school districts without high schools. Maine said, we'll allow religious schools to participate, but they can't do religious stuff. And we're not discriminating against religion, we're just telling them not to do religious stuff. And the Supreme Court says that's a distinction without a difference. As believers, we know that's true. To tell a religious person or organization or school to not teach religion or do religious things or worship or pray is to tell that organization to not be religious. So there's this non-discrimination rule that applies both to organizational character and also to conduct. So what happens after Carson? Well, interestingly, in both Espinoza and in Carson, Justice Breyer says in his dissent, what about charter schools? Now, Justice Breyer, in his dissent, clearly has no idea what a charter school is. It's like word salad. But he has this idea that this is going to have some implications for charter schools, and that's in the ethers after Carson. So we have these laws. They call these schools public. They require them to be secular schools in all 47 states, but they're privately run, and they are government contractors. Okay, so that's the question. I started writing about this around that time, making the argument that after Carson, the laws banning religious charter schools in many, but maybe not all states, were unconstitutional. Around that same time, we had this thing in the months leading up in the years leading up to Carson, we had this thing called a pandemic. You might remember that. And the Catholic Church in Oklahoma was, like all of us, all schools were forced to flip on a dime and start operating virtually. So this happens in 2020. And coming into 2021, even before Carson, the dioceses said to themselves, hey, we're actually not bad at this. We'd like to do this after, assuming we ever get an after the pandemic. We have we operate Catholic schools, and we have a history of operating Catholic schools in very excellent Catholic schools, including for very disadvantaged kids. But large numbers of kids of all faiths in Oklahoma do not have access to religious education, period. Don't have access to a Catholic education because they might be hundreds of miles away from the nearest Catholic school. So maybe what we'll do is start a virtual Catholic school that operates across the state of Oklahoma. But we need some money for that. Now, as chance would have it, the diocese ended up calling me because I'd been writing about this. And they asked, well, what about, could we become a charter school? And I'm like, not really, because it's illegal for you to become a charter school. And they said, well, it just turns out that the guy who was the architect of the St. Isidore School was a law professor, a law and religion professor. He's like, I think maybe that's unconstitutional. What do you think? I'm like, I don't know, yeah? So it's a long story, but to make a long story short, the Attorney General of Oklahoma in 2022 wrote an opinion letter saying that Oklahoma's charter school laws were unconstitutional because they discriminated against religion. And that allowed for the Archdiocese of Oklahoma City and the Diocese of Tulsa to apply to operate a charter school. That charter school was called St. Isidore of Sevilla Catholic Virtual School. It goes to the state charter school board, which was the authorizer. And in order to get the charter school money, they have to get permission to enter into a contract with the charter school authorizer. A divided charter school board approves the school. They decided that the Attorney General was correct, the former Attorney General was correct, that laws in Oklahoma prohibiting religious charter schools were unconstitutional. They violated the First Amendment because they discriminated against religious organizations and religious conduct. But in the meantime, there is a new Attorney General in Oklahoma named Gunther Drummond. Is anyone related to Gunther Drummond? Okay, so I won't tamp down my snark about Mr. Drummond. Mr. Drummond, he changed his mind. He issued a new letter that said, that other idiot was wrong. It not only violates the Oklahoma Constitution, to have authorized religious charter schools. It also violates the Establishment Clause of the United States Constitution because they're public schools and you can't have religious public schools. And very bizarrely, he says over and over again, also, the Catholics might be fine, but you know who's coming next is the Muslims. And he says this over and over again in public statements, in his briefs, in his press releases. It's very weird. Radical Islamic schools teaching Sharia law. I'm like, I want to help an Islamic school become a charter school. Bring it on. Anyway, Mr. Drummond sues the State Charter School Board having entered into a contract with St. Isidore in Oklahoma Supreme Court. And our client, St. Isidore, intervenes in that action. The Oklahoma Supreme Court rules that it does, in fact, violate the Oklahoma Constitution and the U.S. Establishment Clause, the federal Constitution, to allow a charter school to be religious. There's a cert petition. The court grants cert. Justice Barrett, for reasons that she does not explain, but may have something to do with her long-term affiliation with Notre Dame Law School, where I teach, recuses. So eventually what happens is the court 4-4 affirms the lower court order, so that has no precedential effect. And so they answer the question, does it violate the Establishment Clause, the Free Exercise Clause to ban religious charter schools, or does the Establishment Clause require states to ban religious charter schools? Still there. And I assume it will be answered again. So in the time I have left, I just want to talk briefly about what the case was about and what it wasn't about, and then maybe a couple of things about what might come next, because we don't have an answer. So there's a lot of commentary about this case, a lot of hand-wringing and hysteria, that this was opening, taking a sledgehammer to the last brick in the wall between separation of church and state. It was opening the door to religious public schools, traditional public schools, that like the ones I attended, that are operated by school districts, and that this was really dangerous for American democracy. But the case in the Supreme Court was really about one question and one question only. And on both sides agreed on this, by the way. Was St. Isidore of Sevilla Catholic Virtual School a government actor or a private actor? And the real question, you guys probably know the state action doctrine, which is a mess, but the real question in the case was when the Archdiocese of Oklahoma City and the Diocese of Tulsa, St. Isidore is a private, not-for-profit corporation, or is no more, it's been dissolved, but had two members, the Archbishop of Oklahoma City and the Bishop of Tulsa. When they entered into a contract to operate a charter school, did St. Isidore Corporation become the Oklahoma? Effectively, because it was so closely controlled, or maybe even created by this contract, was it a public entity, a government entity, the school, in which case everyone agreed that the Establishment Clause would bar it from being religious? Or did it maintain its private character, in which case everyone agreed that the Free Exercise Clause prohibited Oklahoma, or the Oklahoma Supreme Court, from ordering the board to dissolve the charter school contract, or to revoke the charter school contract. This is a very odd case because Oklahoma was on both sides. The Attorney General was suing his own state. The state of Oklahoma, the State Charter School Board, which is represented by ADF, argued along with us, the school, and the Solicitor General of the United States, that St. Isidore was a private actor. It maintained its private character. And so therefore, the Free Exercise Clause prohibited the state of Oklahoma from discriminating against it or requiring it to secularize in order to get charter school funds. Mr. Drummond, ably represented by a former Solicitor General of the United States, argued, no, it became a government actor. We don't know why that was tied at spring. I was there. It seemed pretty likely that we were going to win. But the question remains open. Okay, so just a couple of things on what's next, and sort of what we might expect. So the question about religious charter schools is still open, and it might be a different answer in different states because some states control their charter schools quite closely. Some states don't. Oklahoma was pretty free, gave them pretty free rein to innovate. In Oklahoma, there were charter schools that focused on Native American culture, on STEM, on fine arts, on Montessori. There was, the environment. So the ideas are sort of in a state like Oklahoma with relatively light control of charter schools, they may be private actors, and in a state like California with a lot more control of charter schools, they may be government actors. We don't know the answer to that question. It's possible that we'll see some lawsuits in other states soon. I have no idea. For all I know, they're preparing complaints right now. It's possible that, like Attorney General O'Connor, that another state attorney general or a governor might issue another executive order or an opinion letter saying that we're not going to enforce our charter school laws anymore, in which case that state would be sued. And, you know, I don't like to say this, but it's possible nothing will happen because something magical is happening in the United States, which is that as of 2 months ago, when Texas passed its giant ESA, Education Savings Account law, over 50% of school children in the United States now qualify to participate in a private school choice program. So the states that are most likely to authorize religious charter schools don't need them. The states that are least likely to authorize religious charter schools where there is no school choice are not going to do it. So there may be some lawsuits, there may be some legal change, and maybe there's just stasis, and private school choice overtakes the pressure to have religious charter schools. You know, the second thing to think about with what was at stake at St. Isidore and the broader question is that and this came up in oral argument, a decision that a school that operates pursuant to a contract with the government is a government actor by virtue of its contract is a very dangerous decision for civil society and religious liberty, because believers regularly contract with the government in order to advance the common good, and we don't want Catholic Charities or, you know, the Orthodox Union or other religious organizations to become the government and be fully controlled as government entities just by virtue of their cooperation with the government. And then the final thing I will say, because Michael Helfand is here, is that the charter school question is only one question that remains about religious discrimination, probably one of the most complicated questions that remain about religious discrimination after Carson versus Macon. Together with Orthodox Union, Notre Dame's Religious Liberty Clinic has built a website. We'd be happy to share it with you, religioussequality.net, where our goal is to put up, to identify as many public programs at all levels of government, state, federal, and local, that violate the Free Exercise Clause by discriminating against religious conduct. Utah, by the way, is very friendly toward religion. California, New Jersey, not. We've identified at the state level 500 plus programs, that everything from education to social services to building old folks' homes to community development grants to healthcare, where it's really clear that these things are just unconstitutional. So and I think one thing about that broader and the federal government too, the federal government is terrible. One thing about that broader project is it really illustrates how our laws remain infected with a kind of Lemon versus Kurtzman thinking that dramatically curtails religious liberty, particularly in the education space, special education space, community development, healthcare, social services, and we need to convince legislators, executive people, I don't know, people to sue, just so that people can freely exercise their religious liberty without being subject to these unconstitutional laws. And that goes far beyond the religious charter school issue. So thank you.
Good morning. Let me get myself set up here. I'm here to talk to you about what on the surface seems like a fairly dull case with some fairly significant implications. The topic of it, or the title of it rather, is a Supreme Court case that was titled Catholic Charities Bureau, Inc. versus State of Wisconsin Labor and Industry Review Commission. Completely dull kind of bureaucratic title. The question in the case essentially was whether Catholic Charities was entitled to a tax exemption, in this case an exemption from the state's unemployment tax. In Wisconsin, as in most other states, employers are required to pay into the state's unemployment compensation fund. And there's a couple of ways that they can do that. I'll sort of stay away from those details. But for many years, Catholic Charities that has operated in the state wanted to take advantage of an exemption that would relieve them of that duty, in part because the Catholic Diocese of Superior already operated a Catholic-sponsored employment system, which actually in a lot of ways was far superior to the state's program. But to do that, they had to demonstrate that they were eligible for this exemption. The exemption had two conditions, one of which the Catholic Charities folks easily satisfied, and that is that they had to show that they were controlled by a church or similar religious organization. The state easily waved that aside because the diocese controlled Catholic Charities directly. But the second element was the one that the dispute centered on, and that was whether or not Catholic Charities could demonstrate that it's, quote, organized for religious purposes. And Wisconsin disputed that fact in a case that went up to the Supreme Court. Along the way, the case landed before the Wisconsin Supreme Court, which had a very interesting line of analysis. It began in a fairly non-textualist way by saying that it had to construe the exemption narrowly to prevent harming any people that might have otherwise been left without unemployment insurance, which, by the way, wasn't really an issue in the case because even with the exemption, again, Catholic Charities was prepared to take care of anybody, any of its former employees. The court then parsed the word religious purposes. Remember, the organization has to be organized for religious purposes to give them a double meaning. In the first place, of course, you had to point to religious motivations, and there Catholic Charities, hit that one out of the park. There was no question. The statement of faith that was baked into their mission statement, their day-to-day operations, the religious training that they gave their employees, all of it, bespoke the deep religious meaning behind providing charitable services. But then the court moved on to the second element of what it meant by religious purposes, and it said that the Catholic Charities also had to show that its activities were by nature or character religious. And there the court found the Catholic Charities, surprisingly, was not organized for religious purposes. The court managed that move by saying that it wanted to compare the Catholic Charities' activities, that is the actual act of providing food for the poor or shelter for the homeless and so on, with comparable secular organizations. And there the court said there really is no difference between the secular food bank and so on with Catholic Charities. And in particular, the court, drawing on a Seventh Circuit decision, came up with basically a list of elements of what would count as a religious organization. And among them would be the fact that the organization limits its employment or limits its recipients or limits, or in terms of its own religious faith and community, or further, it would use the opportunity to teach and inculcate religion as it was delivering these welfare services. And there, of course, the Catholic Charities folks said, now wait a minute, Catholic doctrine tells us we cannot attach proselyting to the giving of charitable help. And it also tells us we can't discriminate either in employment or in the recipients of our help based on religion. Those factors did not matter to the Wisconsin Supreme Court, and it ultimately found that Catholic Charities was not entitled to the exemption. Well, represented by the Becket Fund, Catholic Charities sought Supreme Court review and got it. The Supreme Court granted review on a single question, and I'll quote it. Does a state violate the First Amendment's religion clauses by denying a religious organization an otherwise available tax exemption because the organization does not meet the state's criteria for religious behavior? Well, in a surprise move, the Supreme Court found unanimously that the Wisconsin Supreme Court was wrong and that its reading of its state exemption law was unconstitutional. So let me highlight it for you. After a long career reading Supreme Court decisions, decisions under the First Amendment are almost never unanimous. It's very rare. We could probably list a handful or so. This was a very unusual decision by the court. The second move was that the Chief Justice assigned the writing of the majority opinion to Justice Sotomayor, of course, one of the court's most famous progressives. There's a real importance to unanimous decision as a practicing lawyer, and that is, it is a strong insulation against change as the court's composition changes. This reflects a strongly held point of view from the entire court, no matter their ideological backgrounds. It's a significant case in that way. Let me very briefly describe for you the nature of the majority opinion, how Justice Sotomayor came about this analysis. Virtually all of her analysis rested on an incredibly important principle that actually tacks quite neatly in with what Nicole has just finished describing. She called the principle denominational neutrality. That means the government is forbidden by both religion clauses from playing favorites based on religion. It's particularly true when it comes to religious denominations. And this principle, she explained, quoting the court's decision in Larson versus Wheatley, is, quote, the clearest command of the Establishment Clause. And Justice Sotomayor added that it's equally required by the Free Exercise Clause. She said that a law that differentiates between religions along theological lines survives under the First Amendment only if it can satisfy strict scrutiny. And there, the Wisconsin court's reasoning, its interpretation of its exemption failed. In the first place, the denial of tax exemption presented what Justice Sotomayor called a paradigmatic form of denominational discrimination, because the state's reasons for denying the exemption all ran along theological lines. That is, a theology that accepted that it would only deliver welfare services to its own faith community got the exemption. But the Catholics, who deeply believe in the duty to care for all of those in need, failed that exemption. Those who would restrict their employment based on faith could get the exemption, while Catholics who had important beliefs about non-discrimination in the workplace could not. She, that is, Justice Sotomayor, saw all of those theological lines, and she compared Wisconsin analysis with, quote, a law exempting only those religious organizations that perform baptisms or worship on Sundays. And like such an organization, the Wisconsin law, quote, establishes a preference for certain religions based on the commands of their religious doctrine. Unsurprisingly, such a law could not survive strict scrutiny. Wisconsin had identified two interests that it said were compelling. One, it said that, quote, the law serves a compelling state interest in ensuring employment coverage for its citizens. Fair enough, that's the basic purpose of any unemployment insurance program. The problem is under-inclusiveness. State law allowed for some 40 different kinds of exemptions for different categories of employers that were not obligated to pay into the system, while at the same time excluding the Catholic Charities organization from that same exemption. The second problem that the court found was that the state had said that its interpretation of the tax exemption was narrowly tailored to avoid entangling the state with employment decisions where an employee has been fired, terminated because of noncompliance with some religious standard. But the problem with that is that it's totally out of touch with the actual shape of the exemption as the Wisconsin court interpreted it. Because after Justice Sotomayor put it, it doesn't make any sense to have an exemption covering both the janitor and the priest in equal measure. And that's essentially what Wisconsin had done. Her opinion begins where it ends, with a firm declaration in favor of the principle of religious non-discrimination. She wrote this: when the government distinguishes among religions based on theological differences in their provision of services, it imposes a denominational preference that must satisfy the highest level of judicial scrutiny. And because Wisconsin failed that test, its interpretation of the exemption failed as well. Let me add a couple of notes in addition. Justice Thomas wrote an incredibly important and interesting concurring opinion in the case, where he addressed the implications for the church autonomy doctrine. That is, the notion that, much as the principles of federalism and separation of powers, the Constitution firmly separates the powers of church and state. We don't expect any church member to tell a mayor or the president exactly how to make a political decision, and vice versa, we don't expect a court to be brokering or deciding questions of religion. Justice Thomas pointed out that the Catholic Charities' claim to the exemption would have been perfectly straightforward except for one choice that was tied to the Catholic's internal organization. And that is, unlike some faiths, because of Catholic doctrine, a principle called subsidiarity, Catholic Charities was separately incorporated from the diocese. If it had not been, if it were not simply an arm of the diocese, but sort of collected in under a single corporation, the Wisconsin court itself had to admit that Catholic Charities would have qualified for that exemption. Justice Thomas wrote in a really interesting and probably the most extended treatment that we have on the church autonomy doctrine of many cases in law. I really can't recommend it enough. There is, by the way, a postscript I want to add before dropping off this. Just yesterday, Supreme Court issued an interesting order remanding a related case from New York State. It was called the Diocese of Albany versus Harris. It basically said that the New York Court of Appeals had to reconsider its earlier decision in light of this Wisconsin case I've mentioned. So let me just say a word or two about the New York case. At issue there is a state law that basically mandates every employer to include abortion coverage with its health care plans, with employee health care plans. And that's been now in litigation for virtually a decade. And this is the second time the Supreme Court remanded in light of a decision. Its earlier decision, Fulton versus Philadelphia, resulted in another 3 years of litigation in which the New York courts essentially said, we really liked our initial decision, thanks anyway. So we hope that this remand may be somewhat more successful. Now, what do I take away from the Wisconsin case? Sort of what's the takeaway going forward? Two things. One, the principle of religious non-discrimination is an incredibly powerful principle, and it could, properly applied, answer many of the conflicts that Nicole has talked about. And in a sense, the court is feeling its way along. But when the case is as clear as it was here, where you have a lower court or a state essentially drawing lines based on theology and religious organization, it's quite willing to step forward even on a unanimous basis. The other closing thought I have is this. As wonderful as that unanimous decision is, I have just a niggling doubt about it. And the niggling doubt is, why strict scrutiny? Why is it that a principle of non-discrimination that comes from both clauses of the First Amendment, why is that not a categorical rule the same way that ministerial exception and church autonomy are? The same logic applies. And it's hard for me to understand exactly the circumstance under which any level of government would be justified in drawing lines among people solely based on religion. And with that, I'll leave you. Thank you.
All right, we have a few minutes for questions. I believe we have some microphones in the room, so I have questions, but I'll defer to any that might be out in the audience before I start asking. So does anybody have a question? No? Oh, here we go. Okay, great. I think that's for the...
On your niggling question about why the strict scrutiny rule rather than the categorical prohibition, it seems like you could certainly imagine a case in which there would be a claim to a religious doctrine for something that was clearly a violation of other people's rights, right? Like a religiously motivated killing or assassination, something along those lines. I would want us to have an opportunity to say, okay, well, there's a compelling state interest in not allowing that kind of a religious practice. Does that?
So I have a thought. I mean, Stephanie Barclay, my former colleague, has a paper called Unal and Brune, don't Brownianize the First Amendment. So the question is a big question, right? So it's a question about in the Second Amendment context, the court has gone into this world where it's either a right or it's not a right, and we don't balance. And one of the big questions in con law now is whether that kind of doctrine will overcome all rights discussions, or whether we'll still have some kind of balancing for the cases like you say. And I think it's actually a really important question. I am not a big fan of made-up tiers of scrutiny. There's so many different tests for balancing. I just find it exhausting. But if, it could end up, I think Professor Barclay's argument is if we went down that road in the First Amendment context, we might get less religious liberty than we want. Because it could be that those rights are narrower, at least as an original matter, than what we're getting under the current balancing regime. So I don't know the answer to the question, but it's a really good one.
Shawn?
Well, I'll tackle it as well, Eric. The alternative to balancing, in my mind, is having a government frame its rules and laws in non-religious terms. I mean, all the hard cases I can think of, including the ones you've mentioned, juvenile snake handling, the children of Christian Scientists, I mean, all the hard kind of conflicts, don't have to turn on rules that actually treat people differently based on religion. Instead, it can actually focus the lawmakers' attention on the nature of the public harm. And even under the most expansive reading of the religion clauses, it's sort of, as Justice Jackson put it, not a suicide pact. We're not, sort of giving everybody free rein to do everything. But what it does is it guides decision makers away from drawing lines based on religion.
Michael?
I was with your first comment. So I think it's a deep error that the court made, but it's not the court now that made it. I think it's the court made it in 1982 when it decided Larson v. Valente. So Larson, you have a case of what the court initially calls denominational preference, but now the court calls denominational discrimination. And the puzzle works something like this, I think. Under the Free Exercise Clause, you're exercising an individual right, and so the court, balances it in ways that you've kind of prefigured with your question, with strict scrutiny. You need, I have a right, but something terrible is going to happen, so we counterbalance it. But Establishment Clause rules typically don't have strict scrutiny, which is what makes denominational preference stick out like a sore thumb. It is the only Establishment Clause doctrine where you have strict scrutiny. And the court kind of, even in Larson, 82, said, this starts to look like a free exercise doctrine. It's just weird. It's like a misshapen doctrine. And I think part of that is because there are some unique features of the case in Larson that made the court kind of focus on the nature of discrimination and abandon the concept in some ways of Establishment Clause denominational preference, meaning one would have thought under this doctrine, the clearest command of the Establishment Clause, as the court says in Larson, that when the government merely prefers religion, even without discrimination, you might still have an Establishment Clause problem. Let me give you an example. In 1984, the Supreme Court, 2 years after Larson, the Supreme Court decides Lynch v. Donnelly. This is a Christmas display case, one of the government religious speech cases. And there's this interesting, I think it's a concurrence, I hope I'm remembering this right, by Justice O'Connor, where she says, don't view the Christmas display as denominational preference, preferring one religion over the others, because there's no discrimination there. Now, hopefully now you see the puzzle. The puzzle is you might have thought that the clearest command, which turns out to be a muddled mess, the clearest command of the Establishment Clause is about a preference, not about discrimination. And hopefully Lynch gives you a sense how those two diverge. I might have a Christmas display that prefers religion without discriminating necessarily, certainly on the face of a statute, without discriminating against other religions. And I think that was an error. And that error led the court to view this doctrine as about discrimination. It gets folded into the Free Exercise Clause, and all of a sudden we end up with, as a result, strict scrutiny. And I actually think that the court's decision, Catholic Charities, is going to cement this error for quite some time. The error is why, at least in my view, the clearest command of the Establishment Clause in 1982, the court has raised how many times since 1982? Maybe Curious Joel v. Grummett in 94. It disappeared off the face of the planet. And the reason why is because who needs it? We have a Free Exercise Clause. It's just the same damn thing. I shouldn't have said it that way. Okay, sorry about that, guys. Withdrawn. The same darn thing. Very good. Okay, good. And that's how you know the doctrines become duplicative. You don't need it anymore. It's misshapen. The whole thing's a complete mess. And I think what you've identified is just one manifestation of the mess. And I think as a result, because the court has done this in a 9-0 opinion, as you described it, I don't think we're ever getting out of this mess. And I think the clearest command is really going to become kind of null.
Well, with that, will you join me in thanking our panelists?